I hate turning that off. Great song. Part 2 of Becha Batchu by Eitan Katz from his Unplugged number 2. How's everybody doing? Great to be with you, learning on a Thursday night. Shabbos is almost here. Let's light up the darkness. Who is with us on a Thursday night? Stephen in New Hampshire, Yehuda in South Carolina, Sharon in Lebanon, New Jersey, Melissa in Great Neck, John in Maine, Nancy in North Carolina, Dawn says shalom, Carrie in Santa Clarita, Bella in Florida, Lucy in Minnesota, Michelle says shalom, Paul in Minneapolis, David in Indiana, Rick and Tina in Tennessee. Michelle is in Washington. Welcome, everybody. Welcome also Yitzhak in Kansas City and Aoife in Florida. Tonight, we are opening a new chapter. Tonight's episode of AT Daily is sponsored by our own Rena Klein. In honor of Sal and Nina, thank you so much, Rena. May you and all your loved ones be showered in blessings. We say amen, and thank you for enabling us to share more Torah with more people around the world. If you'd like to sponsor an episode of AT Daily, it could be just in honor of somebody or in memory of someone. The merit of our learning will accrue to them, even in the world of souls, or for the healing of somebody. Donate.accidentaltalmudist.org is the place to do that. Okay, we're opening chapter 7 here in Tractate Yevamos, the 14th volume of the Talmud. These are the laws of levirate marriage generally, but as we've seen, there's been a lot of implications of the lessons from levirate marriage that just apply to marriage. And something that has come up repeatedly is the case of a priest. And priests have special restrictions on who they can marry. A priest is a descendant of Moses' brother Aaron. So the Kohanim, the descendants of Aaron. And a regular priest, an ordinary priest, may only marry a woman who is he can marry a widow, but he cannot marry a divorcee. A high priest, a Kohen Gadol, can only marry a virgin in her youth, and therefore not even a widow. And as we've seen, well, what if they violate that prohibition and marry somebody who they should not have married? What would the consequences be? Here in chapter 7, we're going to talk a little bit about touching a little bit on these laws of Yibum, but more specifically, so what happens when a woman marries and perhaps that union is prohibited and they're going to pressure the couple to divorce because they should not have married in the first place? Okay, but while they're married, is this considered a complete union even though it was prohibited? And what implications does that prohibition in a prohibited case, or what is the parallel circumstance in a non-prohibited case with respect to property that the spouses bring into the marriage? In modern times, we have concepts of community property. I think California is a community property state. Other states are not community property. And so there's various inheritance laws and ownership laws that have to do with property acquired while a couple is married, property that they bring into the marriage from before they were married. And then this has special implications in the case of a priest, because according to Torah law and in ancient times when slavery was practiced, an interesting wrinkle of slavery was that only a priest could eat consecrated food, right? Food set aside to be consecrated, either, as they're parts of offerings that were given when the temple was standing, certain parts of an offering that went up on the altar. In the case of a burnt offering, was entirely consumed by the altar. But in the case of a sin offering, certain parts of that offering were given to the priests. Or there's teruma. In the tithing process, the initial tithe would go to the priests. So only priests could eat consecrated food. But the Torah made special allowance for the family of a priest to also eat such consecrated food, and the slaves of a priest, meaning the people who live in his house. Right? Slavery was just one kind of employment relationship that existed in ancient times. It sounds, like sort of incomprehensible to the modern ear. We're so repelled by the concept of slavery. But slavery was very widespread and common in the ancient world. At the time that the Torah was given, the Torah came and gave slaves certain rights. And then defined, what those rights are and how they would, affect other areas of law, like teruma. So a slave of a kohen could eat teruma, whereas even, the richest and most prominent and most respected Torah scholar who isn't a priest cannot eat that food. And so, like the greatest Torah scholar in the world, in this sense, has less privilege than the slave of a priest. That's the kind of implication that we'll see here. And in fact, it was even possible for slaves to own slaves in the ancient world, and we'll see that case as well. So, as we listen to these laws, try to, focus on the underlying principles, particularly as they were practiced in the Holy Land when the temple was standing and priests occupied this very important place in society. And even though, there hasn't been slavery and there haven't been priests serving the temple in thousands of years, we still need to understand what the law is. Okay, we open chapter 7 with Mishnah number 1. We are on Daf Samech Vav, page 66, here in Tractate Yevamos. Mishnah number 1. A widow married to a high priest, right, a prohibited union, and a divorcee or a Yevama who performed chalitza, that's a chalutza, right? So a woman who was in a yibum situation, she and her Yavam decided not to perform yibum, not to get married, right? A man died childless and he left a widow and a brother. And the Torah says that man should marry that woman and have a child in the name of the brother who died. But they have the option not to marry and perform chalitza. If they do that, the woman is called the chalutza, and she's like a divorcee. She can marry any other Jewish man she wants, but she may not marry a priest because she's like a divorcee. So a widow married to a high priest and a divorcee or a chalutza married to a common priest, these are all unions prohibited by Torah law. If one of these women brought with her into the marriage slaves of usufruct, or slaves of guaranteed investment, then the slaves of usufruct property do not partake of teruma, but the slaves of guaranteed investment do partake of teruma. We're going to define these terms. The Mishnah will begin to the definition. The Gemara will continue it. But generally, this concept of usufruct, which is a legal term that still exists today, we just don't apply it to people as property. But the idea that in certain situations, you don't buy property, but you get the right to use it, right? You have the right to use it as long as you don't destroy it. So you have a legal right to use certain property, but you don't own it. And if you damage it, you're going to have certain responsibilities. Oh my God. So, here's this idiot sending these kind of typical messages that we are going to ban him. But when these people send these messages, they respond to, members of our class with, I must say that you have tremendous attraction in your beautiful profile, blah, blah, blah. It's some kind of bot, I think. I don't think this is a real idiot watching our show, but maybe because he's deciding who to answer. So, please report these idiots, right? report them as fake accounts, and maybe we can slow down this garbage. It really is annoying. Anyway, so usufruct property is where you have a legal right to use it but not own it, and you're liable if you damage it. So the wife can bring her own property into the marriage that is going to go out with her if they get divorced. It's relevant here because in this prohibited union of a priest with a divorcee, for example, but they got married anyway, so the sages are going to step in and encourage or even force them to divorce since it's a prohibited union. And then she will leave with this property that she brought into the union. You are a jerk, Derek George. It's just annoying in my field of vision. I can't be bothered to report. Nina will do that. Okay, so there's two kinds of ways where they bring property into the marriage that they will leave the marriage with. And we still have that today, by the way. You know, that the spouses, I mean, it's usually talked about in a prenuptial agreement, that kind of a thing, where people bring some property into the marriage that's not going to join the community property, as it were. And if they get divorced, they'll leave with their own property that they brought into it. And that sort of property during the marriage can either be usufruct, right, where the woman brings this property that the husband may use, but if that property increases or decreases in value, that value change accrues to the wife, as opposed to guaranteed investment property that she'll still take with her after when she leaves the marriage, but during the marriage, the change in value will accrue to the ownership of the husband. And why does this matter here? Because of consecrated food. Because when people could be property, when people could be slaves, even Jews could be slaves. So can they eat teruma as a result of now being a slave owned by the priest, even though they became a slave owned by the priest thanks to a prohibited marriage? That's the question they're really examining here. And these are slaves of usufruct property, right? This would be usufruct property, where the husband's just going to get the right to use, but this would be the lowest level of rights that he would have in the property of the wife. These are the slaves of usufruct property. They are those with regard to whom the couple stipulated that if the slaves die, their death is her loss. But if they increase in value, their increase is her gain. And although the husband is obligated in their sustenance, he has to feed them, they do not partake of teruma, as they remain her property and not his. He only owns the right of their use while he is married to her. And the other case is slaves of guaranteed investment. Who are they? They are those with regard to whom the couple stipulated that if the slave dies, the death is his loss, the husband's. And if they increase in value, their increase is the husband's gain. Since he bears financial responsibility for compensating her in the event of their loss, right? If they then get divorced, she's going to leave the marriage with these slaves, since he had sort of ownership of them while they were in the marriage, and then he has to, replace them if they died or something happened to them. So it's his loss, and so those slaves may eat of teruma while the wife and husband are married. In the case of an Israelite woman who married a priest in a halachic marriage, right? This is not a prohibited union. This is any Jewish woman is allowed to marry a priest as long as she's not a divorcee or a widow in the case of a high priest. So in the proper marriage of an Israelite woman who married a priest and who brought slaves with her into the marriage, whether they are slaves of usufruct property or slaves of guaranteed investment, they do partake of teruma. And in the case of the daughter of a priest who married an Israelite and who brought slaves with her into the marriage, whether they are slaves of usufruct property or slaves of guaranteed investment, they do not partake of teruma. Although, as she is the daughter of a priest, it is permitted for her and her slaves to partake of teruma before the marriage, right? As the daughter of a priest, she ate teruma in her father's house. If she owned slaves, they ate teruma as because they're her property and she's the daughter of a priest. once she marries an Israelite, she leaves her father's house and cleaves to her husband and joins his household, and that's why she can no longer eat teruma, and any slaves she brought with her cannot eat teruma anymore either. That's the Mishnah. Now, Gemara on this Mishnah number 1 in chapter 7. The Mishnah states that if a priest married a woman who's forbidden to him, his wife's slaves of usufruct property do not partake of teruma. And the Gemara asks why. So let this case be like that of his acquisition, who acquired an acquisition, as it is taught in a baraisa. From where is it derived with regard to a priest who married a woman and acquired slaves, that they partake of teruma? How do you know that if he acquired a woman who already owns slaves, that she can now eat teruma and her slaves can eat teruma? How do we know that? As it is stated, Leviticus 22:11, but if a priest buys any soul, the purchase of his money, he may eat of it. Right? So obviously if he bought a slave, that's what's said specifically there. But what they're setting up is that since getting married in ancient law is called an acquisition, right? It's not that the wife is the husband's property. She's not his slave in that way, but the marriage contract is worded using the terms like acquisition. And from where is it derived that with regard to both the wife of a priest who acquired slaves and a priest's slaves who themselves acquired slaves, that the acquired slaves may also partake of the consecrated food, the teruma of the priest's household, as it is stated. But if a priest buys any soul, the purchase of his money, he may eat of it, which is interpreted to mean if his acquisition acquired an acquisition, the latter partakes of teruma. And here too, since the slaves of usufruct property belong to his wife, it should be permitted for them to partake of teruma. Why does this usufruct make a difference? Now, it only makes a difference in the case of a prohibited union, right? In a permitted union, the slaves of usufruct property do eat the teruma of the priest. But why in the case of the prohibited union? So the Gemara answers, the principle is that anyone who is fit to partake of teruma can enable others to partake of teruma, and anyone who does not partake of teruma cannot enable others to partake. Since the priest's wife, in this case, does not partake of teruma because her marriage is forbidden, her slaves also do not partake of teruma either. Since it was a prohibited union, she doesn't thereby acquire the right to eat teruma like the permitted wife of a priest would. And the Gemara asks, and is it so that one who does not partake of teruma, him or herself, cannot enable others to partake? But aren't there the cases of a priest who is uncircumcised because it was considered too dangerous for him? Like maybe he was the third child in a family where the first two boys were circumcised and died. So they made a chazaka that it's too dangerous in that family for a boy to be circumcised. So even though this guy is a priest who would otherwise be fit to serve in the temple when the temple is standing and bring offerings on behalf of the Jewish people, because it was unsafe for him to become circumcised, they didn't circumcise him. Now he will not be able to serve in the priest. Now he's still a priest. That designation is not removed from him, but he's disqualified from serving in the temple and apparently from eating teruma. But aren't there the cases of a priest who is uncircumcised because it was considered too dangerous for him? And also impure priests. A priest can only eat teruma when he's tahor, in a state of ritual purity. If he became tameh, for example, he helped bury a corpse, a dead body, a beautiful mitzvah, an amazing deed to help people bury a dead body. But after he touched that dead body, he's going to have to go through a purification process to become tahor again, a 7-day purification process. And during those 7 days, he may not partake of teruma. So here we have this uncircumcised priest and an impure priest, and they are not permitted to partake of teruma. And yet, they enable their wives and slaves to partake of teruma. The Gemara answers, well, that's totally different. In that situation, there is no inherent disqualification rendering them unfit to partake of teruma. The priest, if he somehow got circumcised, even though it was dangerous for him when he was young, then he can eat teruma. The one who is impure because he touched a corpse, for example, once he's purified, he can eat teruma again. So he's not inherently disqualified, and it makes sense that we would not disqualify his wife or his slaves from eating teruma during the temporary time period of his own disqualification. the hindrance to their partaking of teruma is tantamount to a situation where their mouths hurt. And that is why they refrain from eating teruma. It's an idiom. Their mouths hurt, meaning like right now they don't want to eat teruma, or they have a sore in their mouth and the teruma is coarse food, and so they're not going to eat it. But it's temporary, and they don't disqualify their wives and slaves from eating it. So they retain, however, the fundamental right to partake of teruma, and therefore they can enable others to partake of it as well. And the Gemara asks, but isn't there the case of a son born from an incestuous or adulterous relationship, this is a mamzer, who does not partake of teruma, and yet he enables others to partake? How so? If an Israelite woman, right, so she comes from a non-priestly family, and she was married to a priest, and she was subsequently widowed or divorced, right? So she was married to a priest, and then she was widowed or divorced from the priest. At that point, she can no longer eat teruma unless she has a son who is a priest. Then she can eat teruma on account of her son. So if an Israelite woman was married to a priest, and she was subsequently widowed or divorced, and a child from that union married a mamzer and then had a child. So in that case, even if the woman's child is dead, she partakes of teruma due to her grandchild, as she has a living descendant from a priest, even though that descendant is a mamzer, right? I guess the mamzer is even the child of a mamzer is a mamzer, but because this child is a priest, I guess he cannot himself eat the teruma, but he enables his mother or his grandmother to eat the teruma. And although this child does not partake of teruma, he enables his grandmother to partake of it. And Ravina said that the above principle is referring to a case of an acquisition who partakes of teruma. If the acquisition of a priest partakes of teruma, he enables others to partake, whereas an acquisition who does not partake, like his forbidden wife, cannot enable others to partake. Forbidden if she's a divorcee or a widow in the case of a high priest. And Rava said a different solution. Rava said, by Torah law, the forbidden wife's slaves indeed partake of teruma, as they are included in the category of his acquisition who acquired an acquisition. And it was the sages who issued a rabbinic decree prohibiting them from partaking of teruma, so that the woman unlawfully married to a priest would have to say, I do not partake of his teruma, and my slaves do not partake of it either, so that she will realize that she is not a valid wife, but rather she is like a prostitute to him. Her husband will therefore come to divorce her, which is the desired outcome of the sages. They didn't want priests to be married to women who were prohibited to them. Now, I'm sure there were priests in history who, even though they were born as priests, the priesthood was not important to them, particularly after the temple was destroyed. And they said, you know what, I don't care if it's a transgression. I'd rather marry this particular woman, even though she's a divorcee. And they did so. And that's an aveira, right? It's a transgression. They're not supposed to be married. So the sages were trying to, add a little pressure to this couple to divorce, since it's a prohibited union. And one way they could do that is by making it known to them that even though the priest could partake of teruma, the prohibited wife could not, nor the children of such a union. And recall that the child of a priest and a divorcee is not a mamzer, it's called a halal. He's disqualified from serving the priest in the priesthood. He'll never be able to serve as a priest, but he's not a mamzer, which is a different designation. That's the child of an incestuous union, not this kind of prohibited union. So Rav Ashi said a different reason for the prohibition. It is a rabbinic decree, lest she have those slaves partake of teruma even after the death of her husband, the priest. As long as he is alive, they might be permitted to partake of teruma according to Torah law, as she is considered his acquisition and they are her acquisition. But once he dies, she is no longer his acquisition, and her slaves should not be able to eat teruma either. And so it's a fence around the Torah to make sure they don't get to that situation mistakenly. The Gemara asks, however, if that is so, that the decree is lest she have those slaves partake of teruma after her husband's death, well then, if that's our concern, then any Israelite woman who marries a priest should not enable her slaves of usufruct property to partake of teruma either, due to the same rabbinic decree, lest she have them partake of teruma after her husband's death. Rather, Rav Ashi said that the decree is dealing with a widowed priestess, the daughter of a priest, right? So this is the daughter of a priest who's widowed. Now, the daughter of a priest who is married an Israelite, for example, she can't eat teruma while she's married to the Israelite. The Israelite dies, she returns to her father's household, and now she can eat teruma again. Says Rav Ashi, the daughter of a priest who then married the high priest, Rav Ashi said we're dealing with a very specific case. It's the daughter of a priest who married the high priest. She was already a widow. She's the daughter of a priest who married some guy, became a widow, went back to her father's household, and then she married the high priest. Prohibited union, because she's a widow. And now they're saying that this idea that they're not going to let her, in these prohibited unions, allow her slaves to partake of teruma because they might make a mistake. In this particular case, they disallow it because she is likely to rationalize enabling her slaves to partake of teruma after the death of the high priest as follows. Initially, my own slaves partook of the teruma of my father's house. I then married this man, and they partook of teruma of my husband. And now that my husband died, I return to the original circumstance, and therefore they may once again partake of my father's teruma. And she does not realize that this is not so, as initially she did not render herself a woman disqualified from marrying a priest. But now, by marrying a high priest unlawfully after she became a widow, she rendered herself a halala, and both she and her slaves may no longer partake of teruma, even upon returning to her father's house, her father, the priest's house. And the Gemara asks, this works out well as an explanation for the Mishna with regard to a widowed daughter of a priest. However, if that widow who married a high priest was an Israelite woman, what can be said? There's no reason for the decree in that case. And the Gemara answers, with regard to widowhood, the sages did not distinguish between one type of widow and another. Once they issued a decree to one type of widow, they applied it to all widows. Because the simpler the laws are, the more likely people will apply them properly and not come to make mistakes, which was the point of the decree, to protect people from violating Torah laws. It was stated with regard to a woman who brings appraised, guaranteed property into her marital contract with her husband, he is obligated to return it at the conclusion of the marriage, right? This is like her prenup. This is stuff that I own. If our marriage ends, I want to take it with me when we part company. So if she brings appraised, guaranteed property, they have to agree in this prenuptial agreement what that property is and how much it's worth. So she brought appraised, guaranteed property into her marital contract with her husband, so he's obligated to return it at the conclusion of the marriage. Upon collection of her marriage contract, for example, following a divorce, if she says, I am taking my belongings, and he says, I am willing to give you only the monetary value of your belongings, but I'll keep the belongings themselves, then the law favors who? And Rav Yehuda said, now we're on 66b, the law favors her. She may take the belongings. She doesn't have to settle for the monetary value of her belongings. She can take the belongings themselves that she brought into the marriage. But Rav Ami says the law favors him. He can choose to retain the property itself and pay her the monetary value. And the Gemara explains, and you can imagine in a more modern case, like maybe she had a beautiful 57 Thunderbird, right? That was her classic car that she loved, and she brought it into the marriage, and they agreed that if they ever got divorced, she's going to take it with her. It's her car. But it was, their car during the marriage. And then if he said at the time of their divorce, you know what, I really like that car. I'm the one who's been driving it for the last 20 years as you decided you didn't like it, and I've been doing all the maintenance and mechanical work on it. So I'll keep the car and I'll pay you its value. And they would argue about its value when they got married or its current value. Probably the court would say its current value. And he says, I'll give you the money. But she says, no, we had an agreement that I take the car. I want the car, even if it hurts your feelings. And that's the sort of argument that they're having here. Now, the Gemara explains that Rav Yehuda said that the halacha favors her because they are the assets of her paternal family. Maybe she brought that car into the marriage, not because, she loved it so much, because it was her dad's car, and it's very meaningful to her. And so when they divorce, she wants to take it with her because it was her dad's car. as an example, right? So Rav Yehuda said the law favors her because they are the assets of her paternal family, and the family's prestige will suffer if that property itself is not returned. Therefore, that property is hers. But Rabbi Ami says that the law favors him, since the master said in the Mishnah with regard to guaranteed property, if they die, the death is his loss, and if they increase in value, the increase is his gain. Since he bears financial responsibility, right? If that car was totaled during the marriage, he owes her that money, right? Then he certainly would have to pay the monetary value because he agreed to that. Since he bears financial responsibility for their loss, the slaves partake of teruma. That's the difference between a slave and a thunderbird. The slave eats teruma and has the whole law of teruma to reckon with. Apparently, the slaves belong to the husband. Therefore, he is obligated to return only their monetary value, according to Rav Yehuda. Rav Safra said in rejection of Rabbi Ami's reasoning, this is Rabbi Ami's position. Rav Safra disagrees with Rabbi Ami and says, does the Mishnah teach that the slaves belong to the husband? No, when they're talking about a guaranteed investment property in the form of slaves, it teaches only that he bears financial responsibility for their loss, not he owns them, right? So that's another argument that she can take her slaves back with her when they divorce. The Gemara asks, and do they partake of teruma wherever he bears financial responsibility for their loss, even if they are not his actual possession? But didn't we learn in a Mishnah? In Terumot 11:9, an Israelite who rented a cow from a priest may feed it vetches, karshinin, of teruma, since the animal belongs to a priest, right? So imagine a priest has received certain produce as teruma. That isn't necessarily only food fit for humans. It might also be food that humans or animals could eat, and the priest could choose to feed his animals with that teruma. Now, if a non-priest borrows a cow from a priest, and he has his own produce, and the first 2%, he's going to set it aside as teruma to give to a priest, well, now it's very convenient that the priest cow is living in his farm, so he can, instead of giving walking that teruma all the way over to the priest, he can, just send a message to the priest, hey, I'm using this teruma to feed your cow. And then that's permitted. Where am I? But didn't we learn in a Mishnah, an Israelite who rented a cow from a priest may feed it vetches of teruma, this kind of food, since the animal belongs to the priest. Now, with regard to a priest who rented a cow from an Israelite, although its feed is incumbent upon him, he may not feed it teruma because he doesn't own. He has to keep that cow, he has to keep it, healthy and living while it's living with him because he borrowed it from a non-priest, but he may not feed it teruma because he doesn't own that cow. He's only taking care of it. This indicates that the requirement for enabling an acquisition to eat teruma is possession, not responsibility. The Gemara rejects this proof. And how can you understand that the case of the rented cow is parallel to the case of guaranteed property? Though the renter is indeed liable for theft and loss, is he liable for unavoidable accidents, for emaciation, if the cow became thinner or weaker for any reason? Is the borrower liable for that? Or the renter, is he liable for that? Or for any other decrease in its value? No, he is not. In fact, the case of guaranteed property is similar only to the latter clause of that Mishnah. In the case of an Israelite who appraised a cow upon renting it from a priest under an arrangement where they stipulated that he guaranteed its value to the owner. Here he may not feed it vetches of teruma, as it is considered his own because he's responsible for any change in its guaranteed value. However, a priest who appraised a cow upon renting it from an Israelite may feed it teruma because now that he has a much stronger, ownership type of relationship with the cow, that he not only rented but guaranteed its value to the owner, now the priest may feed it teruma while it's in his household. And Rabbah and Rav Yosef said at the conclusion of Rav Nachman's sermon, and they sat and said, it is taught in a Baraisa in accordance with the opinion of Rav Yehuda, and it is taught in another Baraisa in accordance with the opinion of Rabbi Ami. It is taught in accordance with the opinion of Rabbi Ami in the following Baraisa. If a slave's owner strikes him and knocks out his tooth or blinds him in an eye, the slave is set free. That was a revolutionary law when the Torah was given. That if a slave owner harmed his slave in some kind of permanent way by striking him, the slave goes free. Prior to that, in the world, slaves were just at the lowest rung of society with no rights or protection whatsoever. And if a master whipped a slave so much that he killed him, he lost the benefit of that slave, but no sheriff or rabbinic court was going to step in and say anything to that owner. The Torah changed that. So if a slave's owner strikes him and knocks out a tooth or blinds him in an eye, he is set free. Slaves of guaranteed investment go free at the loss of a tooth or an eye caused by the husband, but not at such loss caused by the wife. And this indicates that the slave belongs to the husband. Conversely, it is taught in a Baraisa in accordance with the opinion of Rabbi Yehuda. When a woman brings appraised, guaranteed property into her marriage to her husband, if the husband wishes to sell it, he may not sell it, as it belongs to her. And not only that, but even when her husband brought property into the marriage and added it to her dowry as an appraised, guaranteed gift of his own. So very interesting, right? Before she and maybe her family helping her negotiate agreed to marry him, they negotiated that if the marriage ends, if there's a divorce, he owes her a marriage settlement beyond the minimum marriage settlement that the Torah stipulates of 100 or 200 dinars. They could have said, well, no, she comes from a very, wealthy family. You want to marry her, you're going to guarantee that you're going to stay married to her, or you're going to pay her some big amount. And if they appraised and guaranteed certain specific property that he would give her in the event of a divorce, he owns that property. He's only promised to give it to her if they get divorced. But because of that stipulation in their marriage contract, he loses the right to ever sell that property. It's now considered hers, even though technically he still owns it during their marriage. With regard to a case in which either the husband or wife unlawfully sold this property for subsistence, there was an incident like this that came before Rabban Shimon ben Gamliel, and he said, although the husband executed the sale, he may repossess the property from the purchasers, because that sale should have never been made, and therefore that sale can be voided. You can't sell, right? Like it's a scam that people do, right? Like they stand next to a car like they own it. Somebody walks by and he says, hey, you want to buy this car? And I was like, yeah, that's a nice car. I'll give it to you for $100. Really? Okay, I'll take it. The guy was just standing next to a car. He didn't own it. He has no right to sell that car. Likewise, this husband has no right to sell property that he has stipulated actually belongs to his wife. And if he did sell it, the wife can go and say, I want it back. And she can go to a court, or the husband can go to a court and say, it was a mistake. I wasn't allowed to sell it. And the purchasers have to return that property. Rav said that Rav Nachman said, the law is in accordance with the opinion of Rav Yehuda. Right, so Rav Yehuda is the one who says, right, that it belongs to her. The husband may not sell it. So Rav said that Rav Nachman said the law is in accordance with Rav Yehuda. Now Rav said to Rav Nachman, but isn't it taught in a Baraisa in accordance with the opinion of Rabbi Ami? Right, there's a Baraisa that contradicts this opinion. And he replied, although it is taught in accordance with the opinion of Rabbi Ami, Rav Yehuda's rationale that the wife may take the objects in question because they are assets of her paternal family and their complete removal from her domain would hurt the family's prestige, this is a reasonable argument. The Gemara relates an incident. A certain woman brought into her marriage to her husband a robe. It's an itztela, a fine wool, meleta, in which was deemed guaranteed property by her marriage contract. Imagine if the coat of many colors that Jacob made for Joseph, didn't end up getting mangled in the incident where the brothers sold him into slavery. But, he just wore it all his life as an incredibly beautiful cloak. And then he had a favorite daughter and he bequeathed that coat to the daughter. And then the daughter married, some guy. And brought into it, Joseph's coat of many colors, a thing of priceless, inestimable value. And so she said, okay, well, that is my property of my family. If we ever divorce, I'm taking it back with me. Now, her husband subsequently died, and the orphans took that robe and spread it over the corpse as a shroud. And the woman said, no, that's my property. After my husband died, his children had no right to take that robe and use it as a burial shroud for my husband who died. I did not agree to that, and they can't do it. I want the robe back. So the orphans said, but we use it as a shroud. We don't want to take it off the dead body. So this incident came before Rav Yosef. I'm sorry, who did it come before? I guess it came before Rava. So that was the case. Rava said, no, she cannot take it back. The dead, the corpse, has acquired it. As deriving benefit from anything consecrated for the dead is prohibited. Once they consecrated it for the use of the dead, they can't take it back. But she would say, well, wait a minute, they had no right to consecrate it. You can't give away property, even for the temple, if you don't own it. You can't give my property to the temple. You have no right to do that. So Nanai, the son of Rav Yosef, the son of Rava, said to Rav Kahana, wait a minute. Didn't Rava say that Rav Nachman said that the law is in accordance with the opinion of Rav Yehuda, that the husband cannot sell it? So accordingly, the woman's robe should be returned. He said to him, doesn't Rav Yehuda admit that the robe has not yet been collected? Right? She didn't leave the marriage with it. It's still in the marriage. And since it has not yet been collected, it remains in the possession of the husband, even though he's dead, because now his corpse is, in possession of it. And his inheritors can render its use as a burial shroud prohibited. And his inheritors can render its use as a burial shroud prohibited. I'm not sure what they mean by that. The Gemara adds that in this regard, Rava conforms to a standard line of reasoning. As Rava said, consecration of property, the prohibition against benefiting from chametz, leavened bread, on Passover, and the manumission of a slave release the property from a lien. Meaning, if someone placed an asset under a lien for his debt and subsequently consecrated it, or if the asset under lien is leavened bread and the festival of Passover started, or if the asset is a slave and this person freed the slave, then the lien is released and the creditor must claim his debt from the debtor's other property. Right? So even though the debtor had a lien on this property, it's as if the property was destroyed because it was leavened bread in possession of a Jew during Passover, or because it was a slave, but the owner freed the slave despite the lien. Now the lien is going to have to attach to some other property of the debtor. They can't use that because it says if it's destroyed. The slave is no longer a slave. The chametz is no longer property. And so based on this argument, what? If someone placed an asset under a lien for his debt and subsequently consecrated, or the asset under lien is leavened bread during Passover, or if the asset is a slave and he freed him, the lien is released, then the creditor must claim his, and the creditor must claim his debt from the debtor's other property. So in the case of the robe as well, because it was placed over the corpse, it was consecrated for the dead, and it's as if the robe ceased to exist. When you consecrate it for the use of the dead, it has the same result as if the robe accidentally was, thrown into a fire and it was destroyed. It can't be taken out of the fire in order to give it back to the wife. It doesn't exist anymore. Likewise, when they consecrated it for use as a burial shroud for a dead person, it was no longer available to give back to the wife. Consequently, it is prohibited to derive benefit from it. Therefore, it is released to the woman from under the lien. It is released to the woman from under the lien. It seems it's a little confusing at the end there. And just a note here, the dead has acquired it. It is prohibited to derive benefit from a human corpse or from any object that serves its burial. Therefore, it is prohibited to use any object I'm almost done, so if you have any questions, get them in. It is prohibited to derive benefit from a human corpse or from any object that serves its burial. Therefore, it is prohibited to use any object designated for a corpse or its burial that has been used to that end, like a robe spread over the corpse as a burial shroud. However, one cannot render prohibited an object that belongs to someone else, even by using it for a human corpse. So the argument is it no longer exists as a robe. We consecrated it for use as a corpse. But you're not allowed to consecrate something that isn't yours. And if you did, even for use as a corpse, it would seem that she can take it back. At the very least, if the argument was, if they were having the argument before they put they designated it for use as for the corpse, but they didn't put it on the corpse yet, we would think maybe she could take it back. If they already put it on the corpse, it might complicate it, but I'm not sure whether she could take it back or not. Okay, that's what I've got for us today. Let me see if we've got questions or comments. On Yevamos 66. Got hot in my office while we were on the air. Oh, I'm in the wrong page. Yevamos 66. Sharon, is there a reason why a priest cannot marry a divorcee, or is it simply a chok? So Sharon is asking, is this one of those laws that has a rational reason, or is it simply because God said so? Seems to me that this one is because God said so. It is a form of, sort of elevating the priest's sanctity, and that's what it's in this week's Torah portion, Amor, right? That the priest is held to this higher standard, and there are things that other Jews can do that a priest cannot do, and there's things that a priest can do that other Jews cannot do. And so these special restrictions on who a priest can marry, I think it serves to elevate his sanctity, to make them more special, to make them more elevated, and it kind of like, I think it has the effect of, in sort of increasing that aura of holiness around the priests, which you want, right? When the temple is standing, if the priests are the people who are going to be bringing our most sacred offerings onto the altar, to sort of act as our agent in bringing those offerings up on the altar, we want them held to that higher standard and retaining that enhanced level of holiness. But that's me surmising, and I haven't heard that Rambam, for example, who sort of divided all the laws into mishpatim and chukim. I haven't heard that he would characterize this one way or the other, but it seems to me that this would be like a chok. Lesiuk and Eugenia, what of the law for a kohen who has been divorced more than once? Is he still obligated to marry a virgin? Only the kohen gadol, right? Only the high priest is obligated to marry a virgin. We know that because a regular priest can marry a widow. He just can't marry a divorcee. So whether he was, so interesting, like a Jewish couple, if they get divorced, they can remarry, right? As long as she hasn't gone and married some other guy in the meantime. If she did that, she can't come back and remarry her first husband. But if a priest and his wife divorce, he cannot remarry her because she's now a divorcee. She's his divorcee, but he can't remarry her because she's a divorcee. And I think it doesn't matter how many times a priest marries and divorces, he's always going to have that same rule. He can only marry a woman who is not a divorcee. And if he's a high priest, then he has to marry a virgin and a young virgin, as we saw a couple weeks ago. And finally, Janice, wouldn't the reason be to make sure that the Cohen lineage is 100% sure that it is his child? Well, but you can make sure that it is his child even if he's marrying a divorcee, because in fact, even for a regular Jew marrying a woman who's coming out of a divorce with another man, they have to wait 3 months to make sure she's not pregnant, right? That's how they make sure that any child of the subsequent union is the child of the priest. But I think you're making a good point, Janice, that another reason for these laws has to do with the lineage of the Kohanim, which they want to be very careful about. And we see it's being protected with all kinds of laws, that a priest should not become a halal and a woman should not become a halala, because if she ever entered a prohibited union with a priest, she can't marry some other priest even if she leaves that union. And her child is prohibited if she has a daughter from, if a divorced woman marries a priest and they have a daughter, that daughter is a halala. She can never marry a priest. So they're definitely protecting the lineage and sanctity of the priestly class. Okay, my friends, that's what I've got for us tonight. With God's help, we'll be together again tomorrow, the regular Friday time, noon Pacific. Have a great night.